The certified letter arrived on a Tuesday afternoon in late March, and the moment I saw the return address Pinewood Heights Homeowners Association, my stomach dropped like a stone. I had been living in my modest two-story house in Henderson, Nevada, for 3 years without major incident, but lately things had been escalating with our HOA president. A woman named Karen Daniels, who seemed to think her position gave her authority over every blade of grass and window curtain in the neighborhood. I tore open the envelope standing right there at my mailbox, the desert sun beating down on my neck. The words seemed to jump off the page. Notice of intent to file lien in bold letters across the top. My hands actually started shaking as I read through the document. According to this notice, I owed the HOA $7,342 in unpaid fines, late fees, and administrative charges dating back over 2 years. They were giving me 30 days to pay in full, or they would place a lien on my property which could eventually lead to foreclosure. I stood there in stunned silence. $7,000. I had never received a single fine notice, not one. I kept meticulous records of every HOA payment, every communication, every interaction. I paid my quarterly dues like clockwork, always on time, always in full. This had to be some kind of mistake. I walked back into my house, my mind racing. My name is Daniel Wilson, and I work as a software engineer for a tech company based out of California, though I work remotely from home. I had chosen this neighborhood specifically because it seemed quiet and well-maintained, with reasonable HOA rules that mostly dealt with keeping properties looking decent. The monthly dues were $150, which covered landscaping of common areas, a small community pool, and basic maintenance. Nothing crazy. I spread the notice out on my kitchen table and read through it more carefully. The fines listed were absurd. $300 for unauthorized exterior paint color from April 2023. My house was beige, the exact approved color from when I bought it. I had never repainted. $500 for unapproved landscaping modifications from June 2023. I had planted 3 rose bushes along my front walkway. Rose bushes. The architectural guidelines had an entire section encouraging flowering plants in front yards. $200 for parking commercial vehicle in driveway from August 2023. I drove a Honda Accord. There was fine after fine, each one more ridiculous than the last, each one with compounding late fees and administrative charges that somehow ballooned the total to over $7,000. I grabbed my phone and called the HOA management company number listed on the letterhead. After navigating through an automated menu that seemed designed to frustrate people, I finally reached a human being. Pinewood Heights HOA, this is Jennifer speaking. Hi, my name is Daniel Wilson. I live at 4782 Sage Creek Drive. I just received a notice of intent to file a lien on my property for over $7,000 in fines. There has to be some mistake. I never received any of these fine notices. There was the sound of typing on a keyboard. Let me pull up your account. Wilson, you said, on Sage Creek Drive. Yes, that is correct. More typing. A long pause. Okay, I am seeing your account here. It shows multiple violation notices sent to your address between 2023 and now with escalating fines for non-compliance and non-payment. I never received any of those notices, I repeated, trying to keep my voice calm. And most of these violations do not even make sense. It says I painted my house an unauthorized color, but I have never painted my house. It is the same color it was when I bought it 3 years ago. Well, according to our records, the notices were sent. If you did not receive them, that is not really our problem. You are still responsible for compliance with HOA rules and payment of fines. I felt anger rising in my chest. Can you at least send me copies of these supposed violation notices and any evidence of the violations? Photos, documentation, anything. Another pause. I can request that from the board, but there may be an administrative fee. An administrative fee. To see evidence of fines you are claiming I owe. That is our policy. I can submit your request to Karen Daniels. She is the HOA president. She handles most of the violation enforcement. Of course it was Karen. Over the past year, Karen Daniels had become increasingly aggressive in her role as HOA president. She was in her late 40s, with the kind of haircut that screamed "I want to speak to the manager," and an attitude to match. I had run into her a few times at neighborhood events, and she had this way of looking at people like they were beneath her. A few months ago, she had knocked on my door to complain that my trash cans were visible from the street on a non-trash day. They had been sitting on the side of my house, barely visible unless you were actively looking for them. I had politely moved them further back, but the interaction had left a bad taste in my mouth. "Fine," I said. "Please submit that request, and I want everything in writing. I will pass along your message. Is there anything else?" "Yes, I am formally disputing these fines, all of them, and I am requesting a hearing before the HOA board. I will make a note in your file. Have a good day." She hung up before I could respond. I sat there staring at my phone, feeling a mix of anger and disbelief. This was insane. I had been minding my own business, following every rule I was aware of, and now suddenly I was being threatened with a lien on my property. I spent the next hour digging through my files. I kept digital scans of every piece of mail I received from the HOA, every payment confirmation, every newsletter. I went through 2 years of records. There was not a single violation notice, not one. I checked my email, thinking maybe they had sent electronic notices. Nothing. I even checked my spam folder going back 2 years. Still nothing. This was not a mistake. This was deliberate. I grabbed my laptop and started researching. I had never been the litigious type, but something about this felt deeply wrong. As I dug into Nevada HOA law, I discovered some interesting things. HOAs were required to follow specific procedures when issuing fines. They had to provide written notice of the violation with specific details. They had to give homeowners an opportunity to cure the violation or request a hearing. They had to follow their own governing documents, which were legally binding contracts. And if they did not follow these procedures, the fines could be considered invalid. I pulled up the Pinewood Heights CC and Articus the covenants, conditions, and restrictions that governed our HOA. I had read them when I bought the house, but now I went through them with a fine-toothed comb. Section 7.3 dealt with violations and fines. It was very specific. Before imposing any fine, the board had to send written notice via certified mail describing the violation in detail. The homeowner then had 15 days to respond or cure the violation. If the violation continued, the board could impose a fine, but only after a hearing where the homeowner had the right to present their case. None of that had happened. None of it. I pulled up the paint color issue specifically. According to the fine notice, my house was painted an unauthorized sage green as of April 2023. I walked outside and looked at my house. It was beige, tan. The color had never changed. I went back inside and found my home inspection report from when I bought the house. There were photos of the exterior showing the same beige color. I pulled up Google Street View and went back through historical imagery. My house had been this exact color since at least 2019. I took fresh photos from every angle, making sure the metadata showed the current date. The commercial vehicle violation was equally absurd. I pulled up my car registration. Honda Accord, 4-door sedan, personal vehicle. I took photos of my car in the driveway with the license plate clearly visible. The landscaping violation mentioned unpermitted hardscape installation. I had never installed any hardscape. No pavers, no retaining walls, nothing. The only thing I had done was plant rose bushes, which were explicitly allowed under the guidelines. I had even purchased the bushes from a local nursery recommended on the neighborhood Facebook group by Karen herself. Each violation was fake, completely fabricated. But why? What possible reason could Karen have for doing this? I thought back over the past year, trying to remember any interaction that might have triggered this. Then it hit me. 6 months ago, there had been a special meeting to discuss a proposed dues increase. Karen wanted to raise the quarterly dues from $150 to $300 per month. She claimed it was necessary for various improvements, though she had been vague about specifics. I had attended that meeting along with probably 40 other homeowners. I had not been the only one opposed to the increase, but I had been one of the more vocal ones. I had asked for a detailed budget breakdown, questioned some of the proposed expenses, and ultimately voted against the increase. The measure had failed by a significant margin, much to Karen's obvious fury. A few other homeowners had also opposed the increase. I wondered if they had received similar notices. I pulled up the neighborhood Facebook group and sent private messages to 3 people. I remembered speaking up at that meeting: Robert Chen, Maria Rodriguez, and Frank Sullivan. I kept it simple. Hey, have you received any unusual communications from the HOA lately? I just got hit with a notice of Lien for violations I never knew about, wondering if this is happening to others. Within an hour, all 3 had responded. Robert had received a notice for $4,000 in fines. Maria had received one for $5,000. Frank had received one for $6,000. All of them claimed they had never received any prior violation notices. All of them had voted against the dues increase. This was not a mistake. This was retaliation, and it was fraud. I called a lawyer the next morning. I found a local attorney named Patricia Morrison who specialized in HOA disputes. Her reviews online were excellent, and several mentioned her success in taking on abusive HOA boards. Her office was in downtown Henderson, and she agreed to see me that same afternoon. Patricia Morrison was in her mid-50s, with short gray hair and sharp eyes that seemed to take in everything. Her office was lined with law books and case files. She listened carefully as I explained the situation, occasionally taking notes but mostly just absorbing the information. When I finished, she leaned back in her chair. "Do you have copies of everything? The Lien notice, your payment records, your research on the violations?" "Everything," I said, pulling out a folder I had prepared. Photos, documents, the CC and Articus with the relevant sections highlighted. I also contacted 3 other homeowners who received similar notices. They all voted against the dues increase Karen proposed last fall. Patricia flipped through the documents, nodding slowly. "This is good, very thorough, and you are absolutely right about the procedural violations. Nevada law is very specific about how HOAs must handle fines and liens. They did not follow any of the required procedures." She looked up at me. "The fact that multiple homeowners who oppose the board are being targeted suggests a pattern of retaliation, which makes this even more serious." "Can we stop the lien?" I asked. "Yes, we will file for an injunction immediately, but I think we should go further than that. What they are doing here is not just procedural misconduct. If these violations are fabricated, as you claim, and if they are attempting to place liens based on fraudulent claims, that could constitute several criminal offenses. Fraud, extortion, possibly others. My eyes widened. Criminal charges, potentially. At minimum, we can file a civil lawsuit for attempted fraud, harassment, and violation of your rights under Nevada HOA law. But given the pattern here and the amounts involved, there may be grounds for criminal charges as well. She tapped the Lien notice. They are threatening to take your home based on fake violations. That is serious. I felt a strange mix of vindication and anger. What do we do first? First, I draft a response to this Lien notice formally disputing every violation and demanding they provide evidence of proper notice and legitimate violations. We cite the specific procedural failures. Second, I request an emergency hearing before the board, which they are required to grant under their own CC and Articus. Third, I file for a temporary restraining order preventing them from placing any lien until this is resolved. And fourth, I start building a case for a lawsuit. How much is this going to cost me? I asked, worried about legal fees. Patricia smiled slightly. My standard rate is $300 an hour. But in cases like this, where there is clear wrongdoing by an HOA, I often work on contingency for the civil suit. If we win, my fees come from the settlement or judgment. For the immediate work, the response, the TRO, the hearing prep, I would need a $5,000 retainer. But honestly, based on what I am seeing here, I think we have a very strong case. HOAs have a lot of power, but they are not above the law. When they abuse that power this blatantly, courts tend to come down hard. I thought about it for maybe 10 seconds. Let us do it, all of it. We spent the next hour going through everything in detail. Patricia asked pointed questions about dates, about my interactions with Karen, about the neighborhood dynamics. She took copious notes and made several copies of my documentation. By the time I left her office, I felt like I had a plan. More than that, I felt like I was fighting back. Over the next 3 days, Patricia worked fast. She filed the response to the Lien notice, formally disputing every single violation and demanding evidence. She requested an emergency hearing. She prepared a motion for a temporary restraining order. And she sent everything via email and certified mail to both the HOA management company and Karen Daniels personally. The response from Karen came within 24 hours, and it was exactly what I expected. A terse email from her personal address saying that the violations were legitimate, that proper notice had been provided, and that my frivolous legal threats would not change the fact that I owed the money. She copied the entire HOA board on the email, clearly trying to create a record of defiance. Patricia's reply was a masterpiece of professional restraint. She simply stated that if proper notice had been provided, we looked forward to reviewing the evidence at the scheduled hearing. She also noted that a temporary restraining order had been filed with the Henderson Justice Court, and that a hearing on that TRO was scheduled for the following Monday. That weekend, I connected with Robert, Maria, and Frank in person. We met at a coffee shop in Henderson, away from the neighborhood. All three of them had similar stories: fines for violations that either never happened or were never properly communicated. All of them had been threatened with liens, and all of them had voted against Karen's dues increase. I think we need to present a united front, Maria said. She was a high school teacher, probably in her 30s, with a no-nonsense attitude. If she is doing this to all of us, we should all fight back together. Agreed, said Robert. He worked in finance and had an analytical mind. I have been going through the HOA financial records. Did you know that, as homeowners, we have the right to inspect those? I requested them last week. They have to provide them within 10 business days. What are you looking for? I asked. I want to see where the money is going. Karen claimed we needed that dues increase for necessary improvements. But when I drive around the neighborhood, I do not see any improvements. The pool looks the same. The landscaping is the same. So where is the money going? Frank, a retired police officer in his 60s, leaned forward. I have seen this kind of thing before, not with an HOA but in other contexts. When someone abuses their authority to retaliate against people, there is usually something else going on, some other reason they are getting aggressive. My guess. There is financial misconduct happening, and Karen is trying to intimidate anyone who might look too closely. You think she is stealing from the HOA? Maria asked. I think it is possible, Frank said. Think about it. She wanted to double the dues. Why? If she is skimming money, she needs more money coming in to cover it up. We voted down, so now she needs another way to bring in cash. Fake fines against people who opposed her. $7,000 from Daniel, 4 from Robert, 5 from Maria, 6 from me. That is $22,000 right there. I felt cold. That would make this even more serious. Yes, it would, Frank agreed. If we can prove financial misconduct on top of the fraudulent fines, we are talking about embezzlement, fraud on a larger scale. That is prison time. Robert nodded. I will go through those financial records with a microscope when I get them. If there is anything off, I will find it. We agreed to stay in close contact and to coordinate our responses. Patricia had told me that having multiple victims with the same pattern of abuse would strengthen any case significantly. The TRO hearing was on Monday morning at 9. I took the day off work and met Patricia at the courthouse. It was a standard courtroom, smaller than what you see on TV, with maybe 20 seats for observers. Karen Daniels was there with a lawyer, an older man in an expensive suit named Gregory Hughes, who apparently specialized in representing HOAs. Judge Linda Martinez presided. She was a no-nonsense judge in her 50s who had a reputation for not tolerating nonsense in her courtroom. Patricia had told me this was good for us. The hearing was relatively brief. Patricia presented our motion for a temporary restraining order, preventing the HOA from filing a lien pending resolution of the dispute. She outlined the procedural failures, the lack of proper certified notice, the lack of opportunity to cure violations, the lack of any hearing before fines were imposed. She presented my documentation, showing that the violations themselves appeared to be fabricated. She noted that 3 other homeowners had received similar notices, suggesting a pattern of abuse. Gregory Hughes argued that the HOA had followed all proper procedures, that notices had been sent, and that homeowners were responsible for compliance regardless of whether they claimed to have received notices. He suggested I was making up the claim that I had never received violation notices to avoid paying legitimate fines. Judge Martinez asked pointed questions. Mr. Hughes, do you have proof that these notices were sent via certified mail, as required by the CC and Articus? The management company has records of notices being sent, Your Honor. Were they sent via certified mail? A pause. I would have to check with the management company about the specific method of delivery. The CC and Rs, which you are presumably familiar with, specifically require certified mail for violation notices. Do you have certified mail receipts showing these notices were properly sent and received? Another pause, longer this time. I will need to obtain those records from the management company, Your Honor. Judge Martinez looked unimpressed. Miss Morrison, Has your client received any certified mail from this HOA regarding violations? No, Your Honor. Mr. Wilson keeps meticulous records. He has never received any certified mail regarding violations. The first communication he received about any of this was the notice of intent to file a lien. The judge flipped through the documents in front of her. And Mr. Wilson is claiming these violations are fabricated. You have evidence supporting that. Extensive evidence, Your Honor. Photographs showing his house is the approved color and has always been that color, despite claims he painted it an unauthorized color. Vehicle registration showing he drives a personal vehicle, not a commercial vehicle. Documentation showing the only landscaping he did was planting rose bushes, which are explicitly permitted under the guidelines. All of this is in the supporting documents we filed. Judge Martinez looked at Gregory Hughes. Mr. Hughes, does your client have evidence supporting these violations? Photographs, inspection reports, anything? I am sure that evidence exists, Your Honor. I will need to obtain it from the HOA board. You are sure it exists, but you do not have it today. We were not anticipating needing to provide such detailed evidence at this stage, Your Honor. This is just a TRO hearing. Judge Martinez leaned back in her chair. Mr. Hughes, your client is attempting to place a $7,000 lien on Mr. Wilson's property, which could ultimately result in foreclosure. And you are telling me you do not have evidence that the underlying violations even exist. That strikes me as problematic. I had to suppress a smile. This was going well. Your Honor, the HOA has broad authority to enforce its rules and regulations, Hughes argued. Courts have consistently upheld HOA authority in these matters. HOAs have authority within the bounds of the law, Mr. Hughes. They do not have authority to ignore their own governing documents or to fabricate violations. And right now, what I am seeing suggests that is exactly what may have happened here. She looked down at the documents again. I am granting the temporary restraining order. The HOA is prohibited from filing any lien against Mr. Wilson's property pending resolution of this dispute. Furthermore, I am ordering the HOA to produce within 15 days all evidence supporting the alleged violations, including any photographs, inspection reports, and proof of proper notice via certified mail. If they cannot produce that evidence, these fines will be dismissed. We will schedule a follow-up hearing for 3 weeks from today to review that evidence. She banged her gavel. Next case. I felt a wave of relief wash over me. It was not final victory, but it was a major step. As we left the courtroom, I saw Karen Daniels in the hallway speaking tersely with Gregory Hughes. She looked angry. When she saw me, her expression turned venomous, but she said nothing. That went very well, Patricia said as we walked to the parking lot. Judge Martinez clearly saw through their nonsense. Now they have to produce evidence they do not have. When they fail to do that, those fines will be dismissed. But we are not stopping there. We are still moving forward with the lawsuit. What are we suing for? I asked. Multiple claims. Violation of Nevada HOA statutes. Breach of the CC and Articus, which are a contract between you and the HOA. Harassment. Attempted fraud. Emotional distress. And we will ask for attorney's fees, which courts often award in HOA cases where the HOA acted improperly. I am also going to recommend we file a complaint with the Nevada Real Estate Division, which oversees HOAs. They can investigate and impose penalties. Over the next 2 weeks, things moved quickly. Robert received the HOA financial records and spent his evenings going through them line by line. What he found was damning. Over the past 3 years, there were numerous expenses that did not make sense. Thousands of dollars paid to a landscaping company that none of the homeowners had ever seen working in the neighborhood. Large payments to a consulting firm that had no clear purpose. Reimbursements to Karen Daniels for expenses that were vaguely described as administrative costs or community improvement supplies with no receipts or documentation. Robert compiled everything into a detailed report and sent it to me. "This is embezzlement," he wrote in the email. "I am not a lawyer, but I am good with numbers, and these numbers do not add up. I would estimate at least $60,000 over 3 years has been misappropriated." I forwarded the report to Patricia immediately. Her response was swift. "This changes everything. We need to involve law enforcement. This is criminal." Frank, with his background in law enforcement, agreed to go with me to the Henderson Police Department. We met with a detective named Sarah Pierce who handled white-collar crimes. She was in her late 30s, professional and thorough. We laid out everything: the fraudulent fines, the retaliation, and now the financial evidence suggesting embezzlement. Detective Pierce listened carefully, taking notes. When we finished, she leaned back in her chair. "This is a solid case. HOA fraud is actually more common than people think, but usually it is hard to prove. You have documentation, multiple victims, and now financial evidence. I am going to open an investigation. I will need copies of everything you have." We provided everything. Patricia coordinated with Detective Pierce, providing all the legal filings and documentation we had compiled. The police investigation added a new dimension to everything. This was no longer just a civil dispute. Karen Daniels was now under criminal investigation. The 15-day deadline came and went. The HOA submitted a response to the court, but it was pathetic. They provided copies of regular mail notices that they claimed had been sent, but none of them were certified mail receipts. They provided no photographs of any violations. They essentially admitted they did not have the evidence required by their own CC and Artiques. Patricia filed a motion to dismiss all fines and to impose sanctions against the HOA for frivolous actions. The follow-up hearing was scheduled for a Thursday morning in mid-April. This time, the courtroom had more people. Robert, Maria, and Frank were there, as were several other homeowners who had heard about what was happening. Patricia had also filed motions on behalf of Robert, Maria, and Frank to dismiss their fines as well, based on the same lack of evidence and procedural failures. Judge Martinez took the bench and got straight to business. "I have reviewed the evidence submitted by the HOA. Or rather, the lack thereof. Mr. Hughes, your client has failed to provide any credible evidence supporting these alleged violations. No certified mail receipts proving proper notice was given. No photographs documenting the violations. Nothing. Do you have anything to say?" Gregory Hughes stood. "Your Honor, the HOA maintains that proper procedures were followed. The lack of certified mail receipts is due to record-keeping issues with the management company, but that does not mean notices were not sent. That is not how this works, Mr. Hughes. The burden of proof is on the HOA to show they followed their own rules. They have failed to do so. These fines are dismissed. All of them. Mr. Wilson, Mr. Chen, Miss Rodriguez, and Mr. Sullivan owe nothing. Furthermore, I am awarding attorney's fees to all 4 plaintiffs, to be paid by the HOA. Miss Morrison, please submit a detailed accounting of your fees." Karen Daniels, sitting behind Gregory Hughes, looked like she wanted to explode. Her face was red, her jaw clenched. "Additionally," Judge Martinez continued, "I am troubled by what appears to be a pattern of abuse of authority by this HOA board. I am ordering the HOA to cease all fine collection activities pending a full audit of their procedures and finances. If I see another case like this from Pinewood Heights HOA, I will not be pleased." She banged her gavel. The relief I felt was immense. The fines were gone. We had won, but we were not done yet. Patricia filed the civil lawsuit the following week. She sued on behalf of all four of us: me, Robert, Maria, and Frank. The defendants were Karen Daniels personally, the HOA board, and the HOA itself. The claims included fraud, intentional infliction of emotional distress, breach of fiduciary duty, and violation of Nevada HOA statutes. We sought compensatory damages, punitive damages, and attorney's fees. The lawsuit caused an uproar in the neighborhood. It became the talk of the community Facebook group. Some people supported us, outraged at what Karen had done. Others defended her, saying we were just troublemakers trying to undermine the HOA. The neighborhood became divided. Meanwhile, Detective Pierce's investigation was making progress. She subpoenaed the HOA's bank records and brought in a forensic accountant. What they found confirmed Robert's analysis. Karen Daniels had been systematically embezzling money from the HOA for at least 3 years. The landscaping company that received thousands in payments. It was owned by Karen's brother, and the work was never actually performed. The consulting firm. Another shell company connected to Karen. The reimbursements to Karen for vague expenses. Completely fabricated. In total, the investigation determined that Karen had stolen approximately $75,000 from the HOA over 3 years. That was a significant amount, enough for serious prison time. In early May, Detective Pierce called me. "We are moving forward with charges. Karen Daniels is being charged with embezzlement, fraud, and filing false documents. We have enough evidence for prosecution. I wanted to give you a heads up before this becomes public." "When will she be arrested?" I asked. "Likely within the next few days. We are coordinating with the district attorney's office." I thanked her and immediately called Patricia, Robert, Maria, and Frank. We agreed to meet that evening to discuss next steps. The news of Karen's impending arrest spread quickly through the neighborhood, though I am not sure how. Maybe someone at the police department talked, or maybe Karen herself got wind of it and told people. Either way, by the time the actual arrest happened on a Tuesday morning, half the neighborhood seemed to know about it. I happened to be home that morning, working from my home office, when I saw the police cars pull up to Karen's house 3 doors down. I watched from my window as Detective Pierce and 2 uniformed officers knocked on her door. Karen answered, and I could not hear the conversation, but I saw her face go pale. They handcuffed her right there on her front porch and led her to a police car. It was surreal. Part of me felt vindicated this woman had tried to steal my home through fraud, but another part of me just felt sad. How had it come to this? How had someone's desire for power and money led them to destroy their own life? The arrest made the local news that evening. "Henderson HOA president arrested for embezzlement," was the headline on the Las Vegas Review-Journal website. The story detailed the charges and mentioned that 4 homeowners had filed a civil lawsuit after being targeted with fraudulent fines. It did not name us, but anyone in the neighborhood would know who we were. Karen's arrest seemed to break something in the HOA board. Within a week, 2 other board members resigned. A third issued a public apology to the community, admitting they had been negligent in their oversight and had allowed Karen too much unilateral authority. The remaining board members called for an emergency special meeting to elect new leadership. The meeting was held at the community center on a Saturday morning in late May. Nearly every homeowner in Pinewood Heights showed up. The room was packed, people standing along the walls. There was tension in the air, but also a sense that change was necessary. A homeowner named David Fletcher, a retired accountant, stood up to speak. "I think we can all agree that what happened here was a failure of governance. Karen Daniels abused her authority, and the board failed to provide adequate oversight. We need new leadership, and we need better systems in place to prevent this from ever happening again." There was widespread agreement. Nominations were opened for a new board. David Fletcher was nominated and elected as president. A younger woman named Emily Washington, who worked as a project manager, was elected vice president. 3 other homeowners who seemed level-headed and trustworthy were elected to fill out the board. David's first act as president was to address the civil lawsuit. "I have spoken with our attorney," he said. "The lawsuit filed by Daniel Wilson, Robert Chen, Maria Rodriguez, and Frank Sullivan is entirely justified based on what Karen did. I am proposing that we settle this lawsuit promptly and fairly. We owe these 4 homeowners an apology and compensation for what they endured." The membership voted overwhelmingly in favor of settlement talks. Patricia negotiated with the HOA's new attorney over the following weeks. The settlement included a formal written apology from the HOA, payment of all our attorney's fees, and $25,000 in damages to be split among the 4 of us. It also included provisions requiring the HOA to implement new financial controls, mandatory audits, and better procedures for violations and fines. It was not a huge payday, but it felt like justice. More than the money, it was the acknowledgement that what happened was wrong and that we had been right to fight back. Karen's criminal case moved through the court system. She initially pleaded not guilty, but the evidence against her was overwhelming. In August, she changed her plea to guilty in exchange for a reduced sentence. She was sentenced to 3 years in prison and ordered to pay restitution of $75,000 to the HOA. The judge, a stern woman named Patricia Crane, did not mince words during sentencing. "Miss Daniels, you were entrusted with a position of responsibility in your community. Instead of serving that community, you exploited it for personal gain. You stole money from your neighbors. When homeowners questioned your actions, you retaliated against them by fabricating violations and threatening their homes. Your conduct was not only illegal but deeply unethical. The sentence I am imposing reflects the seriousness of your crimes and the breach of trust you committed." Karen cried during the sentencing, apologizing and claiming she had made terrible mistakes. But it was too late. She was led out of the courtroom in handcuffs, and I never saw her again. In the months that followed, life in Pinewood Heights slowly returned to normal. The new board was transparent and competent. They implemented quarterly financial reports that were distributed to all homeowners. They established clear procedures for violations, including mandatory certified mail notice and hearings before any fines were imposed. They even reduced the quarterly dues slightly. As it turned out, we had been paying more than necessary once Karen's embezzlement stopped. I stayed in my house, and the whole ordeal became a story I told at dinner parties. People were always shocked by what had happened. "You sued your HOA?" They would ask. "Was not that risky?" And I would explain that it was not about risk, it was about principle. Karen Daniels tried to take my home through fraud and intimidation. She thought she could get away with it because people are afraid to fight back against authority figures, even petty tyrants in homeowner associations. But the law is the law, and when someone breaks it, they should face consequences. Robert, Maria, Frank, and I remained friends. We would occasionally get together for coffee or dinner and reminisce about the whole saga. Frank joked that he should write a book about HOA corruption. Maria said she learned a valuable lesson about the importance of holding leaders accountable. Robert just seemed satisfied that his financial analysis had been crucial in exposing Karen's crimes. As for me, I learned several important lessons. First, always keep detailed records of everything. My meticulous documentation was critical in proving my case. Second, do not be afraid to stand up for yourself when you know you are right. The legal system can be intimidating, but it exists to protect people from exactly this kind of abuse. Third, find good allies. I could not have won this fight alone. Patricia Morrison was an excellent attorney. Robert's financial skills uncovered the embezzlement. Frank's law enforcement background helped us navigate the criminal investigation. Maria's moral support and determination kept us all focused. The whole experience also gave me a new appreciation for the importance of good governance in communities. HOAs serve a legitimate purpose. They maintain common areas, enforce reasonable rules that protect property values, and foster community. But they need oversight, transparency, and accountability. When one person has too much unchecked power, bad things happen. By the time fall arrived, I found myself actually enjoying my neighborhood again. The stress and anxiety of the legal battle had faded. My house was still mine, the fraudulent fines were long gone, and the person who had caused all the trouble was in prison where she belonged. Justice, it turned out, really could prevail. I was working from home one October afternoon when my doorbell rang. I opened it to find David Fletcher, the new HOA president, standing on my porch. "Hey David, what is up?" I asked. "I wanted to talk to you about something," he said. "Do you have a few minutes?" "Sure, come in." We sat in my living room and David got straight to the point. "The board has been talking, and we want to ask you something. We have an open seat on the board and we think you would be perfect for it. After everything you went through, after the way you fought for what was right, we think you would bring exactly the kind of integrity and vigilance we need." I was taken aback. Me, on the HOA board, after everything that happened. "Especially after everything that happened," David said. "You understand better than anyone why checks and balances matter. You know what can go wrong when people abuse their authority. And honestly, having someone with your attention to detail and willingness to ask tough questions would be invaluable." I thought about it for a moment. Part of me wanted to say no. I had spent so much time and energy fighting the HOA. Did I really want to be part of it now? But another part of me saw the logic. The best way to ensure this never happened again was to be part of the solution, to help build and maintain the systems that would prevent future abuse. "Let me think about it," I said. "Can I give you an answer in a few days?" "Of course. No pressure." "Just think it over." After David left, I called Patricia Morrison for advice. "Should I join the HOA board?" I asked. "Is that crazy?" She laughed. "I do not think it is crazy at all. In fact, I think it is a great idea. You have institutional knowledge now. You know what went wrong and how to prevent it. And having someone with your experience on the board would make it much harder for anyone to try something like this again." I talked to Robert, Maria, and Frank. They all encouraged me to do it. "Someone needs to be the watchdog," Robert said. "Might as well be you." A week later, I called David Fletcher and accepted. I joined the HOA board in November, taking on the role of treasurer. It was fitting in a way. I could keep an eye on the finances, making sure every dollar was accounted for and properly spent. The role was not glamorous. Board meetings were often tedious, dealing with mundane issues like tree trimming schedules and pool maintenance budgets. But I took it seriously. I reviewed every financial statement, questioned every unusual expense, and made sure we followed all proper procedures. I never wanted another homeowner to go through what I had gone through. The holidays came and went. On New Year's Eve, as I sat on my back patio watching fireworks light up the desert sky, I reflected on the past year. It had been one of the most stressful and challenging periods of my life, but also one of the most meaningful. I had stood up to a bully. I had fought for justice. I had helped expose corruption and hold someone accountable for their crimes, and in the end, I had won. Not just the legal victory, though that mattered. I had won because I had proven to myself that I would not back down when I knew I was right. I had won because I had found allies and built friendships through adversity. I had won because my home, the place I worked hard to buy and maintain, remained mine. As the new year began, I felt optimistic about the future. Pinewood Heights was a better place now, with better leadership and better systems. The lessons learned from Karen Daniels' fraud and abuse would not be forgotten. And if anyone ever tried something similar again, well, they would find out that this community had learned to fight back. I thought about Karen sometimes, sitting in a prison cell in Nevada, her life in ruins because of her own greed and vindictiveness. I did not take pleasure in her suffering, but I did not feel sorry for her either. She had made her choices. She had chosen to steal from her neighbors. She had chosen to fabricate violations and threaten people's homes. She had chosen to abuse the trust placed in her, and now she was facing the consequences. The following months brought a new rhythm to life. Board meetings every month, where we discussed community issues and made decisions transparently. Financial reports that I prepared meticulously, showing every dollar in and every dollar out. Neighborhood events that felt genuinely friendly again, without the underlying tension that had existed when Karen was in charge. I even became friendly with some of the homeowners who had initially defended Karen. Once they learned the full extent of her crimes, most of them felt betrayed and apologized for not believing us sooner. A few remained bitter, insisting that we had overreacted or that Karen had been unfairly targeted, but they were in the minority. One spring morning, almost exactly a year after receiving that initial Lien notice, I was doing yard work when a car pulled up. A young couple got out, looking around the neighborhood with the excited expressions of first-time home buyers. They walked up to me. "Excuse me," the man said. "We are thinking about buying a house here. What is it like living in this neighborhood?" I straightened up, wiping dirt from my hands. A year ago, I might have launched into the whole story about Karen and the fraud and the lawsuit. But now, I just smiled. "It is a great neighborhood," I said honestly. "Good people, well-maintained, and the HOA is actually competent and transparent now. We went through some growing pains a while back, but things are solid now." "Growing pains?" the woman asked. "Let us just say we learned some important lessons about governance and accountability. But if you are looking for a place with a functional HOA that actually serves the community, this is a good spot." They thanked me and moved on, continuing their tour of the neighborhood. I went back to my yard work, thinking about how much had changed in a year. From being threatened with losing my home to serving on the board that governed it. From being victimized by a corrupt HOA president to helping build a better system. The whole experience had taught me something valuable about standing up for yourself and about the importance of community. When Karen threatened me with that fraudulent lien, I could have just paid the money to make the problem go away. $7,000 was a lot, but it would have been easier than fighting. Many people probably would have taken that path, but paying would have been wrong. It would have rewarded Karen's fraud and encouraged her to continue victimizing others. By fighting back, by proving the violations were fake, by exposing her embezzlement, I had not just saved myself. I had saved the whole community from further abuse. That June, we held a community barbecue at the pool. It was a beautiful Nevada evening, warm but not too hot, with a light breeze. Kids splashed in the pool while adults stood around talking and eating burgers and hot dogs. David Fletcher gave a short speech thanking everyone for their patience during the transition and highlighting how much stronger the community was now. He specifically acknowledged me, Robert, Maria, and Frank, thanking us for having the courage to stand up when things went wrong. The crowd applauded, and I felt a mix of pride and embarrassment. I had not set out to be a hero. I had just been trying to protect my home. After David's speech, an older woman named Helen approached me. She had lived in the neighborhood for over a decade and had always been quiet at meetings. "I wanted to thank you," she said softly. "When Karen was president, she fined me twice for ridiculous things. My garden gnomes were supposedly a violation. I paid the fines because I was scared of what might happen if I did not. Seeing you fight back, seeing that you won, it meant a lot to me. It showed me that we do not have to accept abuse just because someone has a title." Her words hit me hard. I had not known about her situation. How many other homeowners had quietly paid unjust fines, too afraid or intimidated to fight back? Karen's impact had been even broader than I realized. "I am glad we could make a difference," I told Helen. "And if anything like that ever happens again, please speak up. The board is here to serve the community, not to intimidate people." As the evening wound down and families started heading home, I found myself talking with Patricia Morrison, who I had invited to the barbecue. She had become more than just my attorney, she was a friend now. "You know," she said, "I have handled a lot of HOA cases over the years, but yours was special, not just because of the outcome, but because of how you approached it. You were methodical, you kept your emotions in check, you gathered evidence, and you stood firm. A lot of people talk about fighting back against injustice, but you actually did it." "I had a good lawyer," I said. She laughed. "You had good documentation and a strong case. I just helped present it." "But seriously, what you did took courage. HOAs can be intimidating precisely because they have power over your home. Fighting back means risking everything. Not everyone is willing to take that risk." "I did not really see it as a choice," I admitted. "Karen was trying to steal my home through fraud. What was I supposed to do? Just let her? Most people would have tried to negotiate, to compromise, to make the problem go away quietly. You went to war, and you won." I thought about that. Maybe she was right. Maybe I had been unusually aggressive in my response. But it had felt necessary at the time, and looking back, I did not regret any of it. The sun was setting over the desert, painting the sky in shades of orange and pink. I stood there at the community pool, surrounded by neighbors who were no longer just strangers living nearby, but actual community members I knew and cared about. The whole ordeal with Karen had brought us together in unexpected ways. Shared adversity had created bonds. As I drove home that evening, I passed Karen's old house. A new family had moved in a few months ago after her house was sold to cover part of her restitution obligation. They seemed nice, a young couple with 2 small children. They had no idea about the drama that had unfolded just a year earlier, and that was probably for the best. Life moved on. I pulled into my driveway and sat in my car for a moment, looking at my house. My home. The place I had almost lost because of one person's greed and malice. But I had fought for it, and I had won. The house looked the same as it always had: beige paint, neat landscaping with those rose bushes still blooming along the walkway. My Honda Accord parked exactly where it always was, but everything was different now. I was different. I had learned that I could stand up to bullies, that I could navigate the legal system, that I could fight for what was right and actually win. Those were valuable lessons, even if I hoped I would never need to use them again. Inside, I poured myself a drink and sat down at my kitchen table, the same table where I had first read that fraudulent Lien notice over a year ago. My laptop was open to a financial spreadsheet for the HOA next month's budget that I was preparing as treasurer. It was tedious work, making sure every line item was justified and documented, but it mattered. It was how we prevented another Karen Daniels from abusing the system. My phone buzzed with a text from Robert. "Great barbecue today. Glad we all fought back. This neighborhood is worth it." I smiled and texted back agreement. The legal case was closed. The criminal case was closed. Karen was serving her sentence. The HOA was functioning well. Life had returned to normal, or rather, to a better version of normal than before. The story had reached its conclusion, and it was a satisfying one. But in another sense, the story was ongoing. Every month I served on the board, reviewing finances and making sure procedures were followed, was a continuation of the same fight. Every time a homeowner attended a board meeting or asked questions or held us accountable, they were participating in the same process. Democracy, even small-scale democracy in a homeowners association, required constant vigilance and participation. I had learned that lesson in the hardest way possible, by being targeted with fraudulent fines and threatened with losing my home. But having learned it, I was determined to never forget it. Power, even the relatively small power of an HOA board, needed to be watched and constrained. People in authority needed to be held accountable. And ordinary citizens, or in this case, ordinary homeowners, had both the right and the responsibility to stand up when things went wrong. As I finished my drink and prepared for bed that night, I felt genuinely content. Not just relieved that the ordeal was over, though I certainly was relieved, but content in a deeper sense. I had faced a serious threat, I had fought back intelligently and effectively, and I had helped make my community better. That was worth something. That mattered. The next morning I woke up to another beautiful Nevada day. I made coffee, checked my email, and started my workday. Everything was routine, normal, peaceful. And that normalcy, that peace, was something I no longer took for granted. I had almost lost it, but I had fought for it and I had won. And that made all the difference.